In Maryland, it is possible to have your criminal records expunged or shielded. Baltimore County Public Library spoke with Maryland legal aid attorney Tim Darby to discuss this process.
So a criminal record expungement is the complete destruction of a criminal case record. So that means, on any kind of background check, it cannot be held against you. Everything related to that case should be destroyed. A shielding is different because that case record still exists. A law was recently passed in the state of Maryland shielding certain criminal records from the Maryland judiciary case search, and so the general public, they can't find that record using that database. However, if a criminal background check is conducted and a case file that is shielded comes up, it can be held against that job seeker. If a job seeker has a case that is expunged, it cannot be used against them. So let's say that somebody applies for a job that requires a criminal background check, and that background check still somehow comes up and shows that there is this criminal record that was out there at some period of time. If that is expunged, if that job seeker can show the order of expungement, that can't be held against the job seeker. Shielding, it's also beneficial, but it's not the perfect solution like expungement is. So depending on how thorough the background check is, the employer may just find, or they may just use the Maryland Judiciary Case Search tool, and if it doesn't come up, then that's great for the job seeker. But if they do a more thorough dive, then it likely would show up. We use a database called Westlaw at Maryland Legal Aid to try to find those cases that don't show up on the Maryland Judiciary Case Search. There are several databases that over a period of time have scraped the Maryland Judiciary Case Search of the information on there. So even if something isn't showing up now, it may have shown up in the past, and it may have either been shielded or expunged. But that's why it's really important after somebody gets an order for expungement to hold on to it for the rest of their lives, because it still may come up just because of the way that this technology works. But basically, if it's shielded, then you're not going to have that order, and it's unfortunate that the employer would find that and you wouldn't have that defense. They don't need an attorney, but it's always a good idea. Once that individual determines what is and is not eligible for an expungement, all they have to do is file a petition. It's a one-page form. Check a box, fill out your name, your information. It's really, truly very simple. And then they need to file that in whatever courthouse the disposition was entered. The state has 30 days to object. Typically, the only reason that they object is because they think that the attorney who determined what cases are and are not eligible, they think that they messed up. They think they didn't follow the proper formula. And so it really rarely happens that the state does object, but if they do, the case will be set in for a hearing, at which point the judge would determine whether or not the case is or is not eligible for an expungement. If the state doesn't object, then the court should just automatically grant that petition for expungement without the need for a hearing. At that point, the court will alert all relevant law enforcement agencies to purge all of their records having to do with this case. Once that's done, those law enforcement agencies will file what are called certificates of compliance, basically assuring that those records have been purged. When we talk about expungements, it really all depends on the disposition. And so if a case does have a guilty disposition, it may require a 10 or 15-year waiting period, or it may never be eligible for expungement as the law currently stands. Any case that resulted in a disposition of acquittal, which means that the individual was found not guilty, if the case was dismissed, which means the judge closed the case and did not let it proceed any further, or if it ended up with what we call a nolle prosequi disposition, and that's Latin for not prosecuted, if the state's attorney's office drops the charges. Those are automatically eligible for expungement. And actually moving forward, they're automatically going to be shielded from the Maryland Judiciary Case Search, and they'll be automatically expunged after 3 years. However, like we talked about before, during that 3-year period, it can still show up on background checks and hurt an individual who's applying for a job or housing or anything like that. So even though you can't see it on Maryland Judiciary Case Search, it's still out there, and an individual should file a petition for expungement. Again, it always comes back to the disposition. If we're speaking generally about guilty dispositions, then we need to look at the law to see what is ever eligible for an expungement. whenever I see a guilty disposition on someone's case record, the automatic assumption is that it is never eligible for an expungement. However, there are a lot of exceptions to this. Basically, whenever we see that guilty disposition, we look at the law. The law lays out a couple dozen charges that are ever eligible for an expungement after that guilty disposition. And so there's either a 3-year waiting period, a 10-year waiting period, or a 15-year waiting period. So for that 3-year waiting period, that's for what we call nuisance crimes. And that is essentially anything that you would typically think would be charged against an unhoused individual. Things like vagrancy, drinking in public, that kind of thing. And then we have misdemeanors, which typically take 10 years. The most common misdemeanor that we see with a 10-year waiting period is misdemeanor theft. We also see possession of a controlled dangerous substance that is not marijuana. That's a 10-year waiting period. And then there are only a few charges that are eligible for an expungement after a 15-year waiting period. The most common one that we see is second-degree assault. So whenever I get to have the conversation with one of my clients that their record has been completely expunged, it is a fantastic experience. People have been living with these records for years and years and years, and their lives are likely so profoundly different now than their lives were at the times of these cases' origination. And so, just that freeing feeling that this burden is no longer impacting their lives, that's profoundly rewarding to me as an attorney, and certainly to my clients who get to live better lives.